Okay, so very good afternoon, and welcome everyone to this seminar. I do want to be with my introduction rapid like a lightning, because we have a prestigious panel of speakers who will be talking about a mechanism which is not often discussed in public debates. I am Jacopo Monacinaldini, the chairman of the European branch of the Chartered Institute of Arbitrators, or CIArb. My task is to say welcome on behalf of the CIArb and to briefly explain what the CIArb is. But before doing that, I wish to thank the supporters of this initiative. The idea at the beginning was launched by Hillmont Partners, which is a British-Ukrainian law firm, and they proposed the idea to the European branch of the CIArb. Then other partners joined as supporters in the organization of this event, and they are Arbit, the Italian Forum for Arbitration and ADR, then CIS, Arbitration Forum, then the Ukrainian Journal of Business Law, and finally the Ukrainian Legal Practice Weekly. So thanks to all of them. The CIArb is an international center of excellence for the practice and profession of alternative dispute resolution. The growing membership of over 16,000 is based across nearly 150 countries and is supported by a network of 45 branches. CIArb provides education and training for arbitrators, mediators, and adjudicators. It also acts as a global hub for practitioners, policymakers, academics, and those in business supporting the global promotion, facilitation, and development of all ADR methods. It offers a range of resources, including guidance, support, advice, networking, and promotional opportunities, as well as facilities for hearings, meetings, and other events in central London. Now, my dear friend and esteemed colleague Gilles Adab, who is the immediate past chairman of the European branch and currently the vice chair and the partner at Burdenberg Paris, will be introducing the speakers and the program of the webinar. So, Gilles, it's over to you. Thank you.
Mr. Chair, thank you very much. It's an honor to be introduced by you, Jacopo, my friend as well, and esteemed colleague. It's a pleasure to introduce this amazing panel of ours today, and the topic. The topic, starting with that, is about indeed a topic that is not often tackled in events, and we thought that it made sense to well, cool off, meaning as per the Cambridge dictionary, calm down and take some time to think and reflect. As per another dictionary, a cooling off period is an agreed length of time during which a party can decide not to buy something he/she has agreed to buy, or a period during which two groups who are arguing try to improve the situation before they take further action. It's also about calming down, lose enthusiasm or interest. I think with our speakers talking about precisely those very sensitive but critical periods, we won't lose enthusiasm, and I think you will probably gain even more interest about when and how those periods start, whether there's a momentum, how they can be articulated with a mediation to help optimize these periods. Practically speaking, what are the ingredients so that it does not last years and parties do not lose faith in settling or make it reach a successful end. How can mediation, as I said, especially the new mediation rules within the ICSID system, as we will hear soon from Ms. Kyiv, or the IB rules precisely on investor-state disputes, mediation of investor-state disputes, CIArb mediation rules, all those rules, how can they help to optimize these periods? Are there legal, political, economical impediments or requirements? All of that will be covered today. By whom? Well, we have, as I said, a very esteemed panel of speakers. Mr. Andriy Chornus, who's the head of the International Dispute Resolution Practice at Hillmont Partners, precisely who has partnered with the CIArb to put in place this event. This is a firm based in the UK and in Ukraine. He handles complex and high-value matters in all sorts of disputes, both commercial and investment arbitrations. We also have Mr. Dmitry Davidenko, who's an associate professor at MGIMO University in Moscow, where he's also the director and co-editor of the CIS Arbitration Forum, a think tank focusing on dispute resolution involving parties from Russia and CIS. Mr. Domenico Di Pietro, partner with GST LLP, based in Miami and London, which is an international arbitration boutique based in those two cities. Domenico has practiced international commercial arbitration and investment arbitration for nearly 25 years in jurisdictions like Italy, England, and Wales, Japan, and the US. Mr. And I hope I am correctly pronouncing his name, he or he, Hrab Brush. My apologies in advance, sir, for not pronouncing, and I do know that already. Hopefully you will correct me. He's the legal officer of the International Disputes Department at the Ukrainian Ministry of Justice, where he focuses on states' representations in arbitrations, including investment arbitrations. He's also involved in legislative matters such as the ECT modernization and the Ukrainian law harmonization. We also have Ms. Natasha Peter, counsel with Gide in Paris. Natasha is a member of both the Paris bars and the bars of England and Wales, with over 20 years of experience in international arbitration and ADR. And Natasha practices also as a member of the Cornerstone Barristers in London. She practices in Europe, Africa, and the Middle East with a focus on some sectors, such as energy and construction. Patricia Sangali is a partner with SNG and Partners in Milan. She's admitted to the Milan and Madrid bars and acts both as a counsel and arbitrator. She actively works on Polish and Latin American matters, on both transactional matters and disputes, and is also involved before various jurisdictions, including English, Italian, Polish, and Spanish ones. Last but not least, we have Ms. Meg Kyiv, and she will not be the last, precisely the very first one, our keynote speaker, who will be speaking. She's the Secretary General of ICSID since 2009. She's also the Vice President of the World Bank. Prior to that position, she was the head of Canada's Trade Law Bureau for 10 years, doing investment and trade disputes. And even prior to that, she was counsel in the Canadian Department of Justice. As mentioned, we have an amazing panel. We look forward to hearing them. We will hear first from Meg, who's going to tell us about the following topic. And I want to make sure I do state it correctly: cooling off periods, settlement of investment disputes, and the new ICSID mediation rules. Then will follow a debate, which will be presented and moderated by Natasha and Andri, and involving Mr. Harbschak, my apologies again, and Mr. Di Pietro. Meg, the floor is yours. Thank you very much.
Thank you very much. And I'm delighted to join everybody today. Cooling off periods and mediation actually probably have a lot more to do with one another than we typically think. So these topics are both very good ones for us to discuss today. I have a few slides and I would like to share my screen with you so that it will make it easier to follow the presentation. And then we will go into the debate, which I think will be a very interesting one. So what I'd like to start off with is just a little bit about cooling off periods. And I am mostly thinking about cooling off periods in terms of international investment arbitration. We know from studies that in fact there are cooling off periods or provisions for cooling off in more than 90% of international investment agreements. So it's a very standard clause. We've also seen these kinds of clauses in foreign investment laws where you might go to arbitration if you couldn't resolve the dispute. We do not as typically see them in foreign investment contracts, which can also end up in ICSID dispute settlement, but they certainly are a normal feature of the treaties. Now, the typical cooling off period, of course, requires the claimant to abstain from commencing arbitration during that cooling off period, and instead, the claimant is required with the respondent to make efforts to resolve the dispute amicably. So what is intended to do is to suspend all formal steps being taken during that waiting period and to give the parties a very focused opportunity to resolve the dispute. And some might consider it almost a last best chance before the parties get locked into litigation, locked into a more adversarial process, and of course, spending the time and money that goes along with the adversarial process. A classic cooling off period looks like this one. This is taken from the Argentine Australia BIT of 1997, so it's a bit of an older one. And essentially, it requires the parties to try to settle the dispute amicably. And you will see the language that the parties shall, if possible, settle amicably. And then if they're not able to do so, they can go to whatever forums are available. On top of this kind of provision, this is just a standard one, we sometimes see a time period in which the parties can settle or can are intended to pursue the cooling off period. I think the normal time frame from this is about 4 to 6 months, but we have seen shorter ones. In fact, I've seen some that are 2 months long, and we have also seen longer cooling off periods. I believe the longest cooling off period we've seen is 36 months or 3 years. Usually these clauses are placed at the beginning of the provisions on dispute settlement in the treaty, and you'll often find that they are located in the same part of the treaty as other notices. So maybe a requirement to exhaust remedies, a fork in the road, a notice of intent, all of those other types of procedural requirements that can be found in the bilateral investment treaties. And a word of warning here, I think it's very important not to confuse these periods, but rather to look at them as separate requirements, each with their own timing and often each with their own start and end date. So think of them as things that need to be complied with independently and separately. And I think unless it's extremely clear to you, you should not assume that fulfilling one of these, for example, a notice or exhaustion, necessarily means that you have fulfilled the others, or that something like the cooling off period is suspended from running while other time requirements are met. So you may be required to do a number of things in parallel. In terms of the mechanics of a cooling off period, usually they are set off by something we call a trigger letter. And that can be something as simple as a letter to the other side asking to enter into consultations or discussions as part of the cooling off period. Now, the treaty may also have its own requirements for something more specific that needs to be included in that trigger letter. Regardless of the treaty requirement, I think most people believe that it is useful to put at least enough detail into your trigger letter to have a helpful statement identifying the dispute and putting the government on notice of what your concern is, what the dispute is, and perhaps how it could be resolved. And I think if we want, obviously, good faith negotiation, making sure you have that kind of detail in your trigger letter is very important. There are also a few technical things that you need to think about. And one of them in particular is sending the trigger letter to the right government agency. And this can raise a few issues. If you are suing, as often happens, the state, obviously you are going to name the state, but the question is, which department of state or which minister do you send the trigger letter to? Sometimes it would be the Justice Department who receives these, sometimes the Foreign Affairs Department or a Trade Department, or perhaps it's the department who's responsible for the measures in question. So you need to satisfy yourself that you are sending your trigger letter to the right party. And it can get even more tricky if, even though you are naming the state, you are disputing something that comes from a measure by a subnational government, for example, a city or a province. And so when you are doing that, you will also want to give the trigger letter to that subnational government. So usually you'll not be surprised to know that parties err in favor of, perhaps you might say, over notifying, just to make sure the trigger letter gets to any responsible government officer that it ought to get to. In terms of actually arranging a consultation meeting, it is usually, again, quite informally scheduled by the parties, and it is attended by the parties. You may want to have your client there. You may want to have just the counsel, and you may want to have a third-party facilitator. And that's something we'll come back to when we discuss mediation. I think it's fair to say that it is infrequent to date to have a third-party facilitator, and usually this is a discussion between the claimant and respondent. But that is something that parties are thinking about more often, and as we'll see, treaties are addressing more often. And so it's something to put on your list of things to consider when you are going through that cooling off period. There is an interesting question throughout the jurisprudence about whether cooling off is mandatory, is it highly encouraged, or is it optional? And of course, the answer to that in many respects will depend on whether the treaty is worded in a specific way to make it mandatory. So the obvious techniques there, does the treaty say shall enter into consultations, or should make best efforts to resolve amicably? You usually get different variations on that wording. And depending on how clearly it's worded, it may push you more towards the mandatory or the optional. That said, I think it's fair to say that the case law has come up with roughly 2 to 3 basic approaches on this question. The one that I think, and I'm summarizing very broadly, but the one that is perhaps the most mainstream or most frequently adopted by tribunals is that these cooling off requirements oblige the parties to make a good faith effort at a consultation. But if it fails, it does not prevent them from resorting to arbitration or whatever their next step is. And tribunals recognize, as hard as you try, you might not get a resolution. So what they look for is a good faith effort. Technically, you do not have to wait out the rest of the arbitration of the cooling off period if you can show that you made a good faith effort to resolve the dispute amicably, but nonetheless it failed. The thing to remember there, though, is that you must be able to show you made a real good faith effort. And so, for example, if you simply sent a letter saying, let's talk, is that enough to show you made a real good faith effort? Probably not. So you'll want to really make sure you've got that well documented and your efforts well recorded, because the facts really will be important. Under that rubric, there is a sub-issue in terms of futility. And essentially that relates to the situation where you know, without even sending your trigger letter, that it is absolutely futile to talk to the government, that they absolutely will not consider an amicable resolution. And so in some sense, it's almost a waste of time. While the case law recognizes futility as a reason not to go through the cooling off period, the real problem here is that it is very hard to prove futility, and there is a very high bar. And so if that is what you are going to rely on not to go through the cooling off period, you'd be well advised to make sure, again, that it is extremely well documented and you have a very strong case to say it would just simply be futile. The second approach, which happens less often, is one that you might call either jurisdictional, or we've seen in certain cases a question of admissibility. In terms of jurisdictional, that would be the situation where the tribunal says going through the cooling off period and the full cooling off period is a mandatory or absolute precondition to going to the next step. So you absolutely must do this. And if the tribunal finds you did not make that good faith attempt, you might lose your ability to arbitrate the case or have to start all over again. A variation on that is perhaps what you might call an admissibility approach, where the tribunal convenes and says, you did not try to do the cooling off period, so let's just stop for a moment, go and do that, cure that requirement for cooling off, and then we can go ahead. So those are the approaches that you see in terms of the case law. In many ways, I think perhaps because the clauses are variable and because the case law in some respects has been variable as well, there is a discussion among practitioners about whether a cooling off period really is a useful device. And that discussion brings up questions like, is it too late in the dispute for it really to have a productive effect? We know in investor state dispute settlement that it is rare that a state has not had any contact with the claimant before the arbitration starts. And usually there is a long record of the parties trying to resolve it, trying to find a way through. And so the state is usually quite on notice of the problem. So some would say that then having to go through a formal cooling off period really is not that useful, because if it was going to be resolved, that would have already happened. Another concern parties bring up is whether the parties have already shifted to what you might call litigation mode by the time they start their cooling off period. And the idea or the concern here is that instead of truly focusing on trying to resolve the case, what they're really doing is trying to prepare for an inevitable arbitration and looking for the respondent's position, looking for documents, looking for anything that will help them further in the litigation mode. And if they are too much in the litigation mode, obviously you can see how that's not especially compliant with or complementary to actually trying to resolve the dispute. Now, I think it's fair to say that all counsel, both claimant and respondent, should be aware that if the cooling off doesn't work, they will be in litigation mode. And so it makes some sense to have that on their mind. But the debate is whether this totally takes away from the utility of a cooling off period. Another question that comes up is, does this delay the proceeding or the overall resolution? And obviously it depends on how long the clause is or how long is required for consultation. And obviously, while it might, that would be a good thing if it led to a resolution. And finally, the whole question that we talked about earlier, are the clauses too variable and is the case law unpredictable? That said, I think it's fair to say that the treaties that we are seeing, the new generation treaties, are all continuing to include cooling off requests. And I put here, and then you can see I couldn't put it on one slide. I actually had to put it on 2 slides, but an example of what you might call a modern cooling off provision. And this is Article 25 of the new Canada Model BIT, which was just released in 2021. So it's very much hot off the press. The reason I wanted to show you this is because this is the new kind of consultation model, and you can see that it is highly detailed and highly prescriptive. So in the first clause, it says the investor shall seek to resolve the dispute, so trying to make it as mandatory as possible. And interestingly, it says you may use non-binding third-party procedures. So the possibility of facilitation by a mediator, good offices, any of those kind of devices is specifically indicated in the treaty. You then go on to a clause that talks about and gives you a list of the kind of information that must be in your trigger letter. So again, being very prescriptive about what is required to even start off your cooling off period. It goes on as well to talk about any kind of method, and these are often done by video conference, or at least for the first session of a cooling off period, but they can be by any means necessary. The clause then goes on to talk about different time periods. And here you have to be very careful, again, as I said earlier, to make sure that you are in compliance with the time periods that are established in the treaty. And in particular, Article 5 says that you have to have your consultation within 90 days of delivery of the notice. And in particular, Article 7, you can see, says that if you have not had your consultation within 1 year, you will be deemed to have withdrawn the request for consultations. So this approach makes it very clear that it is very much jurisdictional, and it almost puts a limitation period on getting through the cooling off requirement. And this, I think, is what we are going to be seeing increasingly. So it is something to make sure you're very attentive to the special requirements that are increasingly being put into these treaties. So this brings me to the idea in particular of mediation, because generally it is something that parties are encouraging these days in investment disputes, and because the cooling off periods increasingly are indicating that resort to a third-party facilitator could be a very positive way to have an effective cooling off discussion. Because of this, and just because generally both states and investors are much more interested in the use of mediation in investor state, we have developed a set of mediation rules as part of our overall package of investor state amendments for the ICSID convention and additional facility. And we had substantial consultation on this, and you can find full details on the website. But our approach to this in general, or writ large, is that these should be a flexible set of rules that could be used at any time in the process. So they could be used in the cooling off stage, in the notice of intent or pleading stage. They could even be used if parties wanted to after there had been an award of liability, but you had not yet got to damages. So they're meant to be very flexible and used when the parties think they can most advantageously be used. They are also available to be used standalone, simply to have a mediation, or in parallel with other types of dispute settlement mechanisms. And you can see this in particular using mediation in parallel with arbitration. The other thing to note about these mediation rules, and this goes with the approach of trying to make them very much available, is that we specifically put provisions that allow you very easy or simple access to mediation. And two things in particular complement this. Number one is that the proposed mediation rules require you to have a dispute relating to an investment involving a state or a regional economic integration organization. And essentially, that is a very simple entry door into these rules, and it does not require you to prove the more elaborate things that are required under Article 25 of the ICSID Convention. Things like, was there an investment directly or indirectly? All of those more specific jurisdictional issues under convention arbitration. The second key requirement is that the disputing parties consent to mediation. So consent is really the key to all of this. And that could be consent in the treaty. It could be an advance consent where the treaty says we will mediate in good faith if the parties want to. Or, and what I think is probably more likely, it could be simply an agreement between the two parties. So it's not required by the treaty or even offered by the treaty, but the two parties facing a potential arbitration say, let's agree to try mediation. And they make an offer to one another, and then they are off in terms of the mediation process. So our hope was to make this as simple as possible for parties to start the mediation process. Again, once the process has been started, it's a fairly simple and certainly a very party-driven type of process. So you institute this by a request for mediation. It gets registered by the Secretary General, and the parties can choose a sole mediator or co-mediators if they want. And the only requirements or competence requirements are independence and impartiality. So it is left to the parties if they think they need a particular expertise or subject matter expertise in their mediator, they can select that. The mediator has one sole job, and the rule says the mediator's job is to find a mutually acceptable resolution of all or part of the issues in dispute. At the same time, the mediator does not have the authority to impose a resolution on the parties and does not even have authority to make a recommendation unless the parties jointly ask for a recommendation. So you will see a lot of this is meant to provide the best opportunity for parties to talk and to talk openly without being concerned that if they don't finally settle the matter, they'll somehow be prejudiced in their next steps in the case. So you have your mediators in place, and then you have an initial statement, a very short statement of what the dispute is. And you very quickly then meet with the mediator, and you enter something we're calling a mediator or a mediation protocol, which is simply how are we going to proceed going forward, and you start the mediation. And again, classic mediation tools such as caucusing, with the mediator meeting the parties separately, perhaps going back and forth, is very much possible under these rules, or meeting with them together. And I think usually you would expect both. The mediator is able to get expert advice if this is needed throughout the process. All information relating to the mediation and all documents generated in this mediation are confidential unless the parties agree otherwise. So again, this idea that you will not feel prejudiced for next steps if you have to go to an arbitration. And in fact, the very fact that you are mediating is confidential under these rules unless the parties want that to be publicly known. Similarly, the parties cannot rely on any position taken, any admission made, any offers of settlement extended, or views put forward by the parties or the mediator during the mediation, again, unless the parties agree otherwise. So that's the essential sort of approach of these mediation rules. They are classic mediation techniques incorporated in these rules. And we hope that they will be formally approved in the next months as part of the bigger package of ICSID amendments. But I can tell you that we are already administering several investment mediations where the parties by consent have said, let's try mediation, let's try these rules. And so we're already seeing a real interest in trying to resolve investor-state disputes by mediation. And that, of course, gives us some confidence that this could be very much a useful tool in a cooling off period. Another thing that I think it will be very attractive in terms of mediation is the enforceability of the mediated settlement. And there are two particular aspects to think about here. The first, of course, is the Singapore Convention, which has gone into effect, and increasingly we are seeing parties ratify and join on to the Singapore Convention. We designed our ICSID mediation rules specifically to fit the definitions required in the Singapore Convention. And so a mediated settlement under the mediation rules of ICSID would be able to be enforced under the Singapore Convention. So I think that will be useful for parties. In parallel, if you are mediating once your arbitration has started, you might also be able to take your mediated agreement, have it memorialized in an ICSID award, and then it gets all of the enforceability benefits under the ICSID Convention and ICSID Rule 43. So you have here two very, very useful tools in terms of enforceability. And I think that will be important to parties when they're thinking about, is it worth putting the time and effort into a mediation and trying to make that mediation result in a settlement of the dispute. So I hope that this quick review of the mediation rules and the situation under cooling off provisions in treaties has been helpful, and that our mediation rules will make those cooling off periods even more effective. And I'm very much looking forward to hearing the discussion by my colleagues, and I'm glad to answer questions as we go through the rest of the program. Thank you.
Many thanks. Very clear, straightforward, and optimistic. You will see, you'll probably hear from our participants some, let's say, more critical questions. And by critical, I do mean by way of criticism about these periods. And I will have probably one, and that allows me, before I give the floor to Natasha and Andrew for the debate, I would like to remind everyone that they can use the chat box to ask questions for the last part of this session, which will be a Q&A. Thank you very much, Natasha. Andrew, the floor is yours. Thank you very much, Meg, again.
Thank you very much, Jill. I'm delighted to be here, and a big thanks to Meg for a really interesting and engaging presentation. I personally was really interested to hear that mediation is likely to be taking off in this context, and it may be that we're on the eve of revolution or a change in culture in this respect. So for our next segment, as Jill mentioned, the plan is to use Meg's presentation as a bit of a springboard and to pick up on some of the themes that she has introduced for a bit of discussion and debate between our two very eminent panelists. Jill has introduced them already, so I won't introduce them fully. But we have firstly Mr. Hilhi Rabshag, who is a legal officer in the International Disputes Department of the Ministry of Justice of Ukraine. And secondly, Mr. Domenico Di Pietro, who is a partner at GST LLP in London and Miami. So a big welcome to you both. And for our first topic, I thought a good place to start is perhaps at the beginning with the ways in which cooling off clauses are drafted. And in particular, I wanted to pick up a bit on the way Meg describes the ways in which the varieties of ways in which they're drafted. It's clear that a lot depends on this, ultimately perhaps the success or failure of the parties' attempts to negotiate. So perhaps I could ask Domenico on your views for this, and in particular, how specific or detailed do you think these clauses should be? Is it a good idea, for example, to have a defined period of time before arbitration can be started? And if so, what period of time? And what else should be included in these clauses?
Thank you very much, Natasha, and thank you everyone for having me today. And I'm delighted to be joining this very interesting conversation, and I very much enjoyed the presentation that Meg provided us with, and it's very refreshing because it seems that we are going towards the right direction, the way that we at least try and settle the disputes. And before I start, I just want to mention, just to avoid problems within my firm, that we also have an office in DC, as you can imagine, a firm doing a lot of investment arbitration. So I just wanted to say hi to my colleagues there in Washington. And of course, as Meg mentioned today, there is a huge variety of cooling off periods clauses. And that is the result of the development that we experience over 50 years of bilateral investment treaty protection, particularly. And so we have different clauses reflecting the mood or the policies of a specific time, and we can identify at least 2 or 3 different approaches and in most bilateral investment treaties. And that is something that is somehow is also responsible for the perceived inconsistency sometimes of decisions with respect to how, with regard to how cooling off periods clauses should be interpreted and enforced. And I think that this particular point in time, contracting parties, i.e. states, are in a position to make the most of the information available to them, the experience that some of them have already accumulated over the years, or indeed the case law that is mainly available to see and identify the critical issues that may arise when negotiating and drafting a cooling off period clause. And I think that it is extremely wise that states are extremely precise, especially with respect to the fact that exhausting a cooling off period clause and sending a trigger letter particularly is an element that would affect the investor's ability to actually bring a claim against a sovereign state. That is something that is sometimes underestimated. Bringing a claim against a state in international arbitration, it's something extraordinary. It's not something that would exist irrespective of whether a BIT or the ICSID convention were there or not. So it's very important that parties and stakeholders understand the extraordinary nature of bringing a claim against a sovereign. And therefore, I would very much encourage negotiators to be extremely specific and descriptive, even descriptive, but even sometimes adding example with respect to the scope and objectives of the cooling off period clauses, the content of a trigger letter. We will see that later maybe, but it is extremely important that states identifies the steps to be taken, the fact that that requirement will affect the jurisdiction of the arbitral tribunal, or, as Meg suggested, the admissibility of a claim altogether. Then, of course, the amount of time that is required under these clauses, it's the object of negotiation and compromise. On one hand, we have states that, of course, will expect to have a little bit of time to process, to digest the claim, because it is not always the case that states are aware already of nature and scope of the dispute. Sometimes disputes come out of the blue, simply because the state may be implemented energo-omnibus and new provisions that might affect some of the investors. And the state may have limited knowledge of the investor, the investment, and the dispute that the new provision or new law may have created. On the other hand, I think that Meg mentioned a cooling off periods that would provide for 3 years. Then, of course, that you may have an issue because there might be very urgent issues to be tackled in that respect, and therefore, especially going forward, I think that states should somehow organize themselves in a way that would put them in a position to tackle a trigger letter and a potential dispute in a more efficient way, but still a little bit of time it's necessary.
Well, thank you very much, Domenico. I couldn't agree more that precision and clarity in this context is extremely important. And I was wondering then, Jorge, from your Ukrainian perspective, whether there are any particularities that you've seen in Ukrainian VITs, and in particular, any clauses that have been perhaps a subject of debate or a bit controversial.
Hello, everyone. Thanks for such really interested presentation and such actual topic. I really enjoyed the approaches which were in this topic, and I will keep in mind all of thesis. So. Yes, of course, some Ukrainian BITs may establish additional procedure requirements, namely the fork of the road test. It's about the obligatory exhaustion of local remedies or specific time limits for commencing the investment arbitration. For example, it's like some interesting document, the Belarus exhaustion of all local remedies as a precondition for initiating investment arbitration, which is quite an obscure requirement. Therefore, investors should explore the relevant BIT provisions in detail before starting this formal process of negotiations between the investor and the government, so in the case of such BIT provisions, the investor must like to make a good ground for starting this formal negotiations with the government, and after the filing of this like trigger letter, cooling off clause has started, and the status quo was in this trigger letter. And after this moment, the investor will not have an opportunity to change some theses which are in this letter. So, to my mind, the investor must use all time to prepare for such filing or this trigger letter.
Thank you very much, Georgi. So I also wanted to ask a question to you. So as we have heard from the Mac's extremely insightful presentation, it was mentioned that in order to launch the cooling off period, the trigger letter should be sent to the right government agency. So in terms of Ukraine, what should an investor do in order to run into formal cooling off negotiation with the state of Ukraine?
Mm-hmm. To enter into formal negotiations with the Ukraine, an investor should send the trigger letter to the Ministry of Justice of Ukraine, particularly in the Department of International Disputes. In this trigger letter, the investor must write and point some information. For example, he must explain how exactly his or her rights were violated and who are the parties of this dispute, and the relevant legislation for BIT and other legislation, if so, and other circumstances of the disputes, etc.
Thank you. It's all clear. But also maybe you can more elaborate on the possible mandate of Minister of Justice upon receiving the trigger letter. So what particularly the minister can do with it?
Okay, understood. After the receiving of the trigger letter, from the beginning, this process is regulated by the President's of Ukraine decree of 25th of June 2022, number 581. And there is like our step-by-step procedure what exactly the Ministry of Justice must do in the case of receiving of the trigger letter. So during 5 days after the receiving, we must make a list of options for starting these formal negotiations with the party, with the foreign investor. So the first point is to examine the facts and the legal basis of the dispute, which may be brought against Ukraine in foreign jurisdiction. The second is to determine the relevant authorities and organizations, the involvement of which the involvement in disputes is necessary for understanding of the circumstances of the dispute. The next step is the creation of intergovernmental working group, which will be headed by the Minister of Justice or one of his deputies, and include in this group all interested state bodies and organizations. And the last one is the notifying of the cabinet of ministers, or in certain circumstances, President of Ukraine, or the disputes which may be brought against Ukraine. That's all.
So all clear. Thank you a lot, Georgi, for this insightful answer. So Dominika, do you have any practical hints and maybe tips for investors when drafting the trigger letters? So what degree of detail should be described in those letters at this stage?
Oh, thank you, Andriy. Yes, that's a very good question, because normally when you start drafting a trigger letter, you always ask yourself, how much should I say? How much do they actually know about this dispute? And I think that trigger letter should provide all the information necessary for the host state to assess the facts and evaluate the claims that are being advanced by the foreign investor. And in other words, we should put ourselves in the shoes of the state receiving this letter that, as I mentioned before, might be totally unexpected. And if I may mention that, because we have so many representatives from Ukraine, there's a very famous passage from Western Enterprise v. Ukraine, where the arbitral tribunal clearly said that proper notice is an important element of the state consent to arbitration. It allows the state, acting through its competent organs, to examine and possibly, and I think this is very important element, and possibly resolve the dispute by negotiations. And that's the case of the provision, just trying and give an opportunity to the parties to settle. Then, of course, it's very important to identify the investment and the investors, and explain how and to what extent the investor and investment fall within the scope of application of the relevant bilateral investment treaty or investment contract, excuse me. And trigger letters must identify to a reasonable extent the lamented breach of the treaty, again, of the contract, and therefore the factual and legal basis of each claim. Also, the relief sought, the type of relief sought by the investor, and of course, maybe it's not as important, but also the approximate amount of damages sought. And why is this important? Because claims that are not sufficiently identified in the trigger letter and are developed or added during the arbitration in the contentious proceedings may be at risk of being considered as not complying with the cooling off period provisions of the relevant BAT. And also more generally, an incomplete trigger letter would also limit the chances of settling the dispute amicably prior to the instigation of arbitration proceedings. And also one final word that I know that I tend to speak too much. I think what is very important is the language, the tone, the demeanor that investors should take when drafting a trigger letter. I've seen too many trigger letters drafted in a very aggressive way that somehow undermines the possibility to actually settle the dispute at a later stage.
Thank you very much to you both. Moving on then, assuming you have a trigger letter that has been served in appropriate language and completely describing all the disputes, and the cooling off period has therefore started. The next question is the parties' obligations during that cooling off period. And I think Meg made an important point that because these are international law contracts, there would tend to be an obligation to perform your duties in good faith. But concretely, what exactly is the obligation of the parties? How hard do they have to try to show that they have fulfilled their obligations? For example, do they have to serve a letter? If so, how many letters? What if they're not responded to? Do the parties need to agree to meet face to face? Do they need to agree to a mediation? And what actually do they do in practice? I don't know who wants to answer that first. Maybe Domenico, what are your views on that?
Oh, thank you, Natasha. Yes, I'm afraid I'm going to disappoint you because I don't have a perfect recipe, and very much depends on the circumstances of each case. Of course, where the parties are generally interested in the possibility of settling the dispute, they should leave no stone unturned, and they should make all efforts to pursue that goal. In some cases, the disputing parties may already had an opportunity to exchange views even before the trigger letter is served with respect to the scope and the circumstances of the dispute. And one in that situation, one may consider the cooling off period as a last chance attempt to solve the dispute. I believe that the investor, but not just the investor, I think sometimes, and you will have some bilateral investment treaties posing very clearly this obligation on both disputing parties, not just the prospective claimant. And I think that the parties, but generally the prospective claimant, should err on the side of abundance and trying to explain on multiple occasions, multiple chances, the dispute and the intention to settle the dispute, and providing, as we just said, and all the necessary information. I think that also it makes a lot of sense to offer meetings and offer meetings by identifying a number of dates. For example, this is something that I've done in the past on the occasion of maybe on the second, third letter by which we were trying to sit to settle the dispute. We identified a number of dates that we would be available to discuss, and by giving the other party ample opportunities to decide whether they could attend in person or remotely. And so it is very important, as Meg was suggesting earlier today, to create a file, a collection of documents that would show that a good faith attempt was a genuine attempt to settle a dispute or to provide an opportunity to sit and discuss was actually made. Of course, it depends on the circumstances. Sometimes the situation is so exacerbated that it's very, it becomes painful to go through this process, but it's extremely important because it will have an impact on what is going to happen next, be it settlement of the dispute amicably, hopefully, or in the course of the arbitration. And sometimes it's also difficult, and I close here, because I remember this is another personal, a bit of personal experience. And we were trying to set up a meeting, but the other party would only accept to gather and see us on condition that we identified the bottom line for the settlement agreement. And I think that is a way not to really encourage discussion. There is always, in any discussion, even at the highest level, with big corporations or really powerful states involved, there is always a human element, a personal element, and the opportunity to sit together and discuss the issue openly, not through letters. And it's something that should never be underestimated. And that is why I always encourage to offer everyone, states or for investors, to offer the opportunity for a meeting.
Thank you very much, Domenico. So flexibility and openness, I guess, are the keys. Georgi, I was wondering, from a Ukrainian perspective, are there any other avenues particular to Ukraine that an investor may be able to use during this cooling off period?
Yes, Ukraine has few authorities where an investor can get help. So the first is that investor may apply to the temporary special commission of the Verkhovna Rada of Ukraine on investor protection. The second one is the Department of Criminal Law Policy and Investment Protection or the Prosecutor's Office of Ukraine, and the Business Ombudsman Council and Business Ombudsman Council. And it could be also useful to continue negotiations with the state body, which up to the investor violated his or her rights. So,
looking at it more generally, then it's interesting that you're coming from a state perspective. Do you think that perhaps there is a difference in approach between states and investors during this period? Do they have different interests and therefore different avenues that they think are appropriate?
It's an interesting question. An investor that started the cooling off period may not be considered compliant. May not be considered compliant with the BIT's condition on pre-arbitration settlement, unless the investor has made efforts to settle the pre-arbitration dispute with the state. For instance, I prepared a little bit for such discussion, and the arbitral tribunal in the case Murphy Exploration and Production Company International versus the Republic of Ecuador has noted that, I will quote, the obligation to negotiate is an obligation of means, not of results. The agreement. To determine whether negotiations would succeed or not, the parties must first initiate them. The obligation to consult and negotiate falls on both parties. That say that investor that has made a cooling off period, running, should take all possible actions to enter into official negotiations with government, in our case with Ukrainian government, on an amicable settlement. And also Ukraine in its turn is also interested in amicable settlement if if it could be, and if the claim is grounded. But the first step to communicate, to start this communication, it must make the investor, yes. And yes, one more point. In practice, the appropriate action to initiate negotiations is evidenced by participating in the respective working group on BAT dispute resolutions, exhausting meaningful written communications, and also the attending the consultation meetings organized by the relevant governmental authority. As spoke recently Mr. Domenico, it's so important to make many oral meetings, oral discussions, because only written form it's not an effective way to settle the dispute amicably. For this, we must sit together and discuss all positions, all like legal matters of the dispute. And Ministry of Justice, we have a special persons which organize such pre-trial or pre-arbitral in dispute settlement meetings between investors, state bodies, and with participation of Ministry of Justice as a representative of Ukraine, as a lawyer who will give who will give a legal investigation of these disputes. No? And in this forum, sometimes we can settle the disputes.
Thank you, Georgi. So to wrap up, it's very advisable to be proactive for both, basically for an investor who faces the BAT dispute at the cooling off stage. So the main point, as I see it, is just to not waste time and to keep using various efforts in order to settle, and to keep communicating with state authorities and exercising various options that a particular state can provide. So moving forward, I also have a question for a follow-up question for Domenico. So we have heard what should be done during the cooling off period in terms of ensuring full compliance, but what happens in a situation when an investor that is resorting to arbitration breaches the cooling off period clause, and what could be the possible consequences and decisions to be made by the tribunal?
Oh, thank you, Andriy. Yes, that is very interesting. What's next? What if we have somehow proceeded on the basis of the treaty, or maybe we believe that certain steps should not be taken, or we somehow have a difference with the other party with respect to the actual enforcement or one of those provisions. Once again, we have seen that there are so many different types of wording that have been employed in bilateral investment treaties or multilateral treaties for the protection of foreign investment, and sometimes the wording is very permissive, and you have a lot of may or instead of shall, and therefore an argument may be made that not exhausting the procedure should not affect the foreign investors' right to bring a claim and proceed with the claim. And if the issue arises, nonetheless, the arbitral tribunal in the presence of very permissive language, may, as suggested before, accept to continue the proceeding or suspend the proceedings, and giving the parties an opportunity to go through negotiations. In other cases, and I think this is the position I tend to favor, because a too permissive approach may end up in proceeding in producing a very unappealing result, i.e., if the situation or the principle and or the perception that these provisions under bilateral investment treaties are only there to create a much nicer environment, but are not actual mandatory provisions that are necessary, are condition precedents for a claim to be brought, then we may end up in a situation where everyone would simply jump to and start arbitration proceedings without respecting this requirement. And of course, as already mentioned by Meg before, depending on circumstances and the wording and also the factual scenario of the case, arbitral tribunals may conclude that not respecting, not complying with those provisions may result in a lack of jurisdiction of the arbitral tribunal, because consent was not properly formed, or was not properly, consent did not come into existence, and consent by the state to investment arbitration, of course, and or there may be an issue of admissibility of the claim because one element is not in existence yet. So to be perfectly honest with you, Andriy, the consequences for not following to the letter these provisions, these requirements could be dire. And I would encourage any foreign investor to follow these provisions and to exhaust these requirements, and not take the risk of having, to deal with a decision by the arbitral tribunal that they may not like down the road.
Thank you very much, Domenico. It's certainly a complex and a fascinating subject. We could talk about it all afternoon, but I'd like to leave some time for audience questions as well. So I think we need to wrap up the panel. I just wanted to give each speaker maybe 30 seconds to summarize your words of advice for states and for investors who may be facing a big dispute on the eve of a cooling off period. What do you do? What is your advice to them? Yohi.
I'm the first. Okay. I have 3 points. 3 points. The first one, and the most. It's so important not to waste time. The investor must be so active during this cooling off period. The second advice is totally investigation of the relevant BIT provisions, because might all of them potentially could have some pitfalls for investors and for the states also. But investor, as person who initiates this cooling off period, he or she has an exclusive opportunity to investigate all of BIT provisions during time which during all this time till the moment, and only the government authority has a limited period of time, but investor not. And the third advice is try to research some tribunals cases with this BIT, and there the investor can find the answers on questions which he has. And of course, tribunals' awards are not binding for the next tribunals, but sometimes it could be useful for grounding of the legal position. And from this point of view, I think this research is a must-have. Many thanks.
Thank you very much. Sound words of advice. Domenica, do you have any last words for the audience?
Oh yes. I'll try to be short. And first of all, let us bear in mind that states operate differently from private companies. And this is something that foreign investors tend to forget when they approach a negotiation or send a trigger letter because they are lamenting a breach of treaty. And so they should somehow put up with the fact that states may take a little bit more time, and states are very complex organizations with different departments, different organs that may be to be consulted and maybe address the issue. So it would be wrong to expect a quick and definitive reaction or answer from a state. Patience should be exercised. And also within the whole body of states, we have states that behave and are organized differently. So we cannot employ the same strategy or expect to follow the same protocol when approaching a state. I would suggest foreign investors should not lose faith in attempting settlement, and especially somehow by appreciating the length of cooling off periods, because in that period there might be a changing government, and even when, for example, we mentioned futility, futility is very difficult to be demonstrated, and therefore this cooling off period should be respected. But also they should be respected because the situation, as I just said, might change. There might be a change of government, there may be a change of legislation, and the dispute might go away without having to resort to arbitration. And one final question or issue: what should we do in the cooling off period? And I want to go back to what Jill said at the very beginning of this very interesting conversation. He said something, and he gave us the definition of cooling off. I think that is the definition that should apply to the dispute. The dispute should cool off, but the parties should not cool off. The parties should work frantically to try and settle the dispute and try and interact as much as possible within that, at least within that period of time. So the dispute should cool off, but the parties should heat up and do their best to settle the dispute.
Thank you very much, Domenico, and thank you, Georgi, for this insightful and inspiring debate on cooling off opportunities, basically, for an investor and the state to reach a certain settlement, which is definitely in the interest of both parties. So considering that time flies, I would like to move forward to the Q&A session moderated by Patrizia Sangali, a bar-admitted attorney, arbitrator, and a counsel who has particular experience with managing litigations and arbitrations involving English, Italian, Polish, and Spanish jurisdictions. So, Patrizia, floor is yours.
Thank you, Andre, for the kind introduction. And thank you all the speakers for this interesting session. I would like, first of all, to thank also Jacopo and Gilles, the Charter Institute, and the Hillmont Partners, and of course, all the organizers and the speakers. We already have some questions. My task today is to be the moderator during the Q&A session. So I would like, first of all, to address the comment and the question of Mr. Todd Weiler, or Wieler. I do not know the correct pronunciation. I hope Weiler is correct. The comment here is that in 22 years of practice, he never attended a cooling off period meeting under the NAFTA in which the state representatives ever said they possess authority to resolve the dispute. Indeed, they always announced their lack of such authority. Instead, each would invariably claim to only be there to hear the would-be claimant make out its case and never to lay out the state position beyond indicating a belief that there was no merit in the written claim. Thus, he always regarded these meetings as at best a pro forma requirement or was an opportunity for the state lawyers to conduct a later early discovery with unsuspecting opponents. Also, as such, he never recommended having the client join them in the meeting. None of this is to say that he doesn't support the many efforts on the way to encourage mediation and conciliation. And he was involved in a handful of cases in which a resolution was obtained, but in every one of those cases, it was obtained through informal consultation directly with the entity responsible for the alleged breach, rather than with the lawyers representing the state central entity responsible for defending cases. In each case, the entity was a provincial state level government or state enterprise, rather than the federal central level of government. So the question is if this aspect might be an ingredient for future cases of pre-arbitration dispute resolution. And I would start with Meg comment on this.
Absolutely. I think what Todd is getting to is that critique that these do become pro forma or pre-litigation tools. So I think that he's getting to a point that is a valid concern. For that reason, in fact, we put into our mediation rules a requirement for the parties to identify somebody who is authorized to settle the matter and for them to set out the process that would be followed if they were going to settle the matter. So it goes to exactly the point that Todd is saying, and I think probably a good point of practice, which is to make sure that one or more of the clients attend at least the first mediation session so they get a real feel for what is going on and their role in it. One of the other things I think perhaps it's important, and we're certainly trying to address this, is to make sure that states are aware of and understand mediation, that they prepare themselves for mediation, there's a readiness. And in particular, I point there to the checklist that the Energy Charter Treaty and ICSID has on their websites. And it gives you some criteria to think about as to whether you are in a position to respond to and to really fruitfully have a settlement negotiation or a mediation. So I think Todd's completely right. It's very useful to have the client there. I've been in some of these, in fact, in the NAFTA context, and I think it is really important to have the clients there and not to make it a pro forma kind of situation.
Thank you, Meg. Then we have another question from Vivek Rajani. If it is clear that there is a mandatory consultation or mediation requirement prior to arbitration, would parties need to show compliance at the registration stage of the request for arbitration? If there is no compliance, would the Secretary General of the ICSID be entitled to refuse to register the request for arbitration?
May I step here, Meg, and ask whether you have seen any actual case dismissed on that basis, actually, not just theoretically? Thank you.
No, I think it's a great question, actually. We have never refused to register a case on that basis. And that is obviously because the test is quite high. You would need to prove that it is manifestly without jurisdiction on the basis of the claim. So it's very hard to prove that kind of test, which would prohibit registration. And given what the case law is and the potential for, factual considerations about was there good faith negotiation, was there compliance with the treaty clause, what does the treaty clause mean? It's not the kind of thing where you could see registration being refused. So that has not happened to date. And it's hard to, but I guess it's never impossible, but hard to imagine the circumstances where that would lead to a refusal to register, and it would certainly have to be an extraordinarily clear treaty clause that makes it jurisdictional.
Thank you. Thank you. We have another question from Ms. Federica Bocci. From a practical perspective, is it advisable to also put an end to the cooling off period through a formal letter acknowledging that the cooling off period and amicable settlement has proved to be unattainable? In other words, should the same attention paid to the trigger letter be paid also to an equivalent document which marks the conclusion of the good faith effort? Maybe Domenico, Di Pietro,
Yes.
if you would like to
That's
comment
quite a question. It's a very good question, and this is something that we only touched upon before on the issue of futility. I mean, when it's clear that there's no point in attempting or continuing to attempt settlement negotiations, what should we do? Should we stop and start arbitration proceedings? It depends. We do that at our own peril, and sometimes, for example, I remember there is in some of the treaties entered into by the US, for example, there is a provision where it says, I put a note, is in the event that a disputing party consider that an investment dispute cannot be settled by consultation and negotiation, then we can start arbitration. That is a very permissive provision that somehow will give you a little bit extra courage to start the arbitration without having exhausted this provision. Of course, and in some other cases, you don't have that luxury, and therefore you should rather make sure that you complete, you exhaust, you comply with the provision, or you gather a very solid set of evidence showing that you really exhausted and you made all effort to settle, but there was nothing coming from the other side. And as Todd very cleverly said before, as usual, and it takes two to tango. I mean, it's if you're just, you know, talking by yourself, that there's no point in continuing.
Thank you, Domenico. Because we have unfortunately to go to an end, and we have also the conclusive remarks. Just one last question, and here from Mr. Brahim Muli. He requests to give an insight according to your own experience on the ratio or proportion of success leading to effective settlement in cases handled or treated by you in your experience. If you can give a tip, an insight from your experience.
Can I just say something? And I will give you the number of cases that were actually settled in my experience in 25 years. I will not give you the percentage because that might be a little bit disappointing. So let's say that in three cases, a settlement was reached, but it's a tiny fraction. It's very minimal. It's very minimal.
And if I could add to that, I don't know the exact numbers. I haven't seen any, but remember that you know, the idea obviously is that you would settle in the consultation period, but sometimes it sets the tone, and even though you don't settle in the exact consultation period, you may come back to that as the case comes. So it may have a follow-on effect as well. That's correct.
Thank you, Meg. Thank you, Domenico. And well, we have some other questions, but the time is running, so we will try to reply to all these questions by email. Maybe the speakers could do that. And now let me introduce you to Dmitry Davidenko. He's based in Moscow, and he's the director and co-editor of the CIS Arbitration Forum, a think tank focusing on dispute resolution involving parties from Russia and CIS. And well, I would like to give the floor to Dmitry. The floor is yours for the conclusive remarks. Thank you very much.
Thank you, Patricia. Dear colleagues, perhaps the very term cooling off period is somehow misleading, as it's not just about the investors calming down, coming to his senses, or perhaps changing his mind as regards suing the hosting state. And there is general understanding that indeed the purpose of the so-called cooling off provision in the Investment Protection Treaty is to focus the parties' attention to opportunities of amicable settlement at an early stage instead of a protracted litigation. Nevertheless, in some treaties, the provision goes further and makes the pre-arbitration stage a necessary precondition of arbitration. And furthermore, failure to fulfill the duties relating to this stage may even result in adverse consequences for the party, perhaps as an opinion exists, even including damages. Much depends still on the wording of the clause, which in practice are far from uniform. Modern investor-state treaties, as was discussed today, include much more detailed clause on pre-arbitration dispute settlement efforts, which means it is not a mere encouragement to negotiate, but something much more binding. Much depends also on how the arbitral tribunals construe this clause. Perhaps an appropriate remedy for failure by a party to comply with a mandatory pre-arbitration settlement procedure may be sometimes a cost order, that is, that the party should bear subsequent costs of the arbitration, at least in part. Opinions differ whether compliance with the cooling off provision is always useful, or sometimes it just delays the investor's access to justice and serves no practical purpose. Whichever the case, the cooling off provision should not be considered just a waiting room. It is a time to actively seek to resolve the dispute. And this, as was discussed, should be done in good faith rather than formalistically. Indeed, an effort to settle the dispute early and amicably without litigation is a right of both parties rather than just an opportunity. It is important to underline that the cooling off clause imposes duties not only on the investor, but also on the state. As noted in the relevant doctrine, from the investor's perspective, the cooling off provision may be a treaty-based procedural standard of investment protection to find a cost-effective and prompt solution to a dispute whose breach may call for redress. Speakers point out that an efficient tool of early dispute settlement and litigation avoidance is mediation. As noted in the Ancestral Secretariat draft note, possible reform of investor-state dispute settlement, if mediation takes place at an early stage, then the dispute has not crystallized yet, and it may be easier to find creative solutions to solve the dispute. Solutions not limited to financial compensation. Optimal way to mediation is a reference to it in the treaty. Otherwise, after the dispute has already arisen, it may be more difficult to reach an agreement to mediate indeed. To facilitate this procedure, ICSID, Ancestral, and the International Bar Association have developed mediation rules. However, one of the challenges for a successful investor-state mediation perhaps consists in inequality of economic and political powers which usually exists between such parties. An important issue is to ensure the enforceability of the settlement agreement resulting from mediation. And the Singapore Convention serves as a useful instrument to such effect, but unfortunately currently only a minority of states have acceded to it. Therefore, other ways need to be explored. One such way is formalizing the agreement in a consent award. This is possible if the settlement is reached within the period of arbitration. To obtain a consent award, it's necessary to start arbitration. But to start arbitration, you need to comply with the prior settlement cooling off procedures. One should also pay attention to the fact that some jurisdictions, such as the United States, may require that for the consent award to be internationally enforceable, arbitration should start before signing the settlement agreement. Another option is to include into the settlement agreement various provisions to ensure due compliance with its terms by the parties. For example, an escrow agent may be used to reduce the chances that one party will perform to its detriment without reciprocal performance by the other party. If necessary, it may be a third party, such as a financial institution, such escrow agent. Another contractual tool is an arbitration clause to be included in the settlement agreement. And this raises a question which is too complicated to solve it in a few minutes, whether the same person who mediated the dispute may serve as the arbitrator in the same dispute. Apart from that, the settlement agreement may include provisions such as penalty clause, maybe a bank guarantee, maybe an often agreement of the parties to sign necessary further documents. And last but not the least, the agreement should include waiver by the state of its sovereign immunity with regard to any dispute which may arise from the agreement. Well, summing up, for mediation to be successful, as many people agree today, genuine desire of all the parties involved is necessary. As regards both investors and states, it is recommended to develop dispute prevention policies and efficient case management. And all this would help to comply with the pre-arbitration procedure for the benefit of all the participants. Thank you for your attention.
Thank you to all our speakers, and I will give the floor to buckle the buckle to Jacopo to conclude and thank everyone on behalf of the EB. I would like to thank everyone, but more generally, I believe Jacopo would like to say a few words to wrap it up. Thank you.
Thank you, Jill. I think I might just give a feedback as a personal feeling. I'm really enthusiastic to have been able to listen to this webinar, because to be honest, I'm not an expert on this phase of the settlement mechanisms, and so I really appreciated the intervention of all of you. A special thank to Mrs. Meg Kinnear for her precious time. That has been very key to have her telling us also the insights for the future trends at ICSID. Thank you to all the friends who joined us in this webinar as attendees or as speakers. I think that's it, and again, thank you all, and hope to see you soon.